All right, well, I'm going to go ahead and get started. Alex, you're well familiar with our webinar series. So we have two tracks of webinar series that we have each month. One is focused on intellectual property, which is what we are here to talk about today. The other is focused on foundational entrepreneurship skills. And that one is all about taking that spark and making it a startup. So for the webinar today, as you know, it's a small group and we all know each other. Alex, you'll get to know Justin very well in a second. Please just go ahead and unmute, ask questions throughout. There's no need to hold in any burning questions until the end. We want this to be as interactive as possible. So today we are joined by Justin Poplin. Companies of all sizes rely on Justin's legal advice on patent and other intellectual property issues. Many clients use Justin as outside general counsel because he efficiently prevents and solves problems in ways that minimize disruption to their businesses. Justin has been the lead attorney in litigated IP matters and argued and won some of the earliest inter partes review cases at the Patent Office, including the first inter partes review case invalidating a design patent. He has also successfully argued appeals at the U.S. Court of Appeals for the Federal Circuit, and he has helped clients obtain, enforce, license, invalidate, and avoid infringement of patents, trademarks, and copyrights in a wide range of technologies and industries. Justin is a co-managing partner at Avic IP and previously served as the chair of intellectual property prosecution and transactions department in a national law firm. With that, Justin, we are so happy to have you here with us today, and I will hand it over to you to take it away.
Excellent. Thanks, Jay. All right, here we go. I appreciate the introduction. And with that, today's focus is looking at ways to overcome patent barriers. So the emphasis is going to be on designing around. And there are some other ways to address patent barriers as well, and we'll touch on those, but the focus is going to be designing around. So to get there, we're going to discuss patent infringement, the design around process, and we're going to do it through an interactive seminar. And Alex, that means you get to have a lot of input today. So in some ways, we're going to tailor this a lot to you, and hopefully this is useful to folks who view it later. And at the end, we're actually going to put this into practice. So we'll get some practice designing around and seeing what the process is and making it useful and tangible. So when you're done with your startup, you'll have a better understanding of what is patent infringement, what constitutes patent infringement, and how do we make changes to our products, or how do we design our products so that there is no infringement? How do we make things different? And I'd like to provide a little bit of context, because it could be easy to sit back and think that what we're doing is somehow wrong or underhanded, and that's absolutely not the case. So with patent infringement, that's bad. But designing around, that's actually a purpose of patent law. So here's a court quotation. But the takeaway is that by designing around existing patents, it's something that benefits the consumer. It brings a flow of new products to the marketplace. It can make products better or cheaper, and that this is something that's actually encouraged. So we're not doing anything bad here. By avoiding patent infringement, this is good. Okay, Alex, how much patent experience do you have? Have you dealt with patent claims? Give me some background.
Not really. I'm working with one project, and I'm trying to patent some of the core algorithm of it's an adaptive learning platform for medical students. But like I didn't get there to finalize the patent for the algorithm, or that figure out the study journey for the students.
Okay, so I'm going to use that as a benchmark and assume a lot of other folks who will be watching this also don't have a lot of patent background, and that's great. So let's spend a little bit of additional time diving into that. So we're going to start with patent claims. And then we'll step back and look at patent infringement more broadly. So patent claims are what actually define your patent coverage. If you're going to sue somebody for patent infringement, you pick up the patent document and you flip past the pretty drawings, you go past the written description, and at the very end, there's a section called the claims. And it says, I claim, and it'll start with number one, and it'll lay out what's actually claimed. So those are the claims. That's the focus in any patent infringement case. I'm not suggesting that the drawings aren't important, that the written description isn't important, but all of that really comes secondary to the claims and is there to support the claims. And there's two types of claims. There's something called an independent claim and a dependent claim. And this is important to understand because by understanding this portion, it's going to help us a lot in the design around process. So a independent claim is a claim that does not refer back to another claim. So claim one it'll say, I claim number one, a something, and then it'll provide the information. And then claim two can either also say a something and provide the information, or it can say the something of claim one and then further narrow it. So if it refers back to claim one, it's a dependent claim. And it includes everything that was in that first claim plus more stuff. So you cannot infringe the dependent claim unless you infringe the independent claim. Let's look at an example. Basic example. This is, I tried to tailor it to New Orleans. A sandwich comprising a first portion of bread, a second portion of bread, and at least one source of protein between the first portion of bread and the second portion of bread. That's claim one. So it's the basics of your sandwich. Okay, that's an independent claim because it doesn't refer back to something else. Claim number two, it says the sandwich of claim one, wherein the at least one source of protein includes at least one piece of fried shrimp. So it ties back to claim one and it gives you more details. Okay, if someone doesn't infringe claim one, they cannot infringe claim two. This is very, very important for infringement analysis. Because if you just look at claim two and say, is claim two infringed without looking at claim one, it's being done wrong and you're on the wrong path. Okay, and then you can further define the scope through additional independent or dependent claims. So claim three, the sandwich of claim two, further comprising at least one piece of lettuce. So by the time you're at claim three, you've got the two pieces of bread, a source of protein, which you know is at least a piece of fried shrimp, and you've got lettuce. And then claim four, I've used that to further narrow it to where it says at least one piece of lettuce is adjacent to the at least one piece of fried shrimp. So the lettuce can't be on the outside of the bread. It has to be, or at least they have to be together. Okay, now we also could have taken claim three, and instead of going back to claim two, we could have gone back to claim one. So claim three could have read the sandwich of claim one, further comprising at least one piece of lettuce. And then you would have had whatever source of protein you wanted with a piece of lettuce. Does that make sense? So this is a way to stack information together. Dependent claims are extremely useful, especially with validity challenges. If claim one doesn't stand up, claim two might, or claim three might. So you can have a lot of different claims, and at the end of the day, it's really useful more for challenges and validity. So you don't want to ignore dependent claims, but for what we're doing today for infringement purposes, we are going to, and that's okay and that's appropriate. But when you're getting your patent, don't ignore them. I know we've had a few other people join. Please feel free to ask questions, to talk. You should not be muted unless you want to be muted. I'm really hoping that this is interactive today.
I do have a question here. Let's say my thing is in code. Does that mean I write every step in the code for validation inside that?
No. So your code is going to be protected through copyright law. So patents for software, you typically set forth what they're doing that's different. So what it's doing big picture wise, what you're controlling, how you're getting there. If the processing is different, you want to lay out those steps. So in code, you would think of it as if you had a flow chart that described how your software behaved, you're more interested in that flow chart than the actual lines of code. Does that make sense?
Yes, thank you.
Okay. Hopefully we've got a clear idea of independent claims versus dependent claims and the importance of those to a patent, because that really is the heart of your patent. Now, before we can design around, we have to know what infringement is. So let's look at the different ways of infringing. The most basic way of infringing is through what's called direct infringement. And that is, if you don't have the right to do so and you make, use, sell, offer to sell, or import a patented invention, you're an infringer. It's that simple. Any of those things. And patents are by country, so this all relates to the United States. If you make something in China, sell it in China, you are not infringing a US patent because you're not doing anything here. If you make something in China, you import it into the United States, you're an infringer. If you make it in China, you sell it into the United States, you're an infringer because the selling is here or the importation is here. So it's all country by country. But those are the important aspects: make, use, sell, offer to sell, and import. There's also something called indirect infringement. So there's inducement, and that's if you actively induce infringement of a patent, you're liable as an infringer. So that is, I don't do all of the things that are there, but I told somebody else to. That's a problem. That's inducement. Also, there's contributory. So contributory is if you're selling a component that's not a commodity and it's really made to do something that infringes, then you can't get away from infringement by saying, I didn't do the whole thing, because you sold the thing that allowed somebody else to infringe. So if you're selling it and that's the only use for it, that's contributory infringement. If you're selling it and there's multiple uses for it, but you tell somebody to go and infringe somebody's patent, that's inducement. Okay? This is the universe of infringement. Either you infringe directly or indirectly. And most of the focus is going to be on direct infringement. If any of this doesn't make sense, please speak up. Okay, next issue. What is infringement? How do you get there? Infringement's a two-step process. Step number one, if we go back and we look at the claim that we made up, just the sandwich claim, the first step is going to be, what does it mean? What does that claim require? And that's often called Markman, based on a case, or claim construction. So if we go back up to our example claim, a first piece of bread, well, is a cracker of bread. And you'd look to the specification, you would bring in experts, and you would argue over whether or not a cracker is a piece of bread. So every single word matters. And when you're litigating it, we fight over every single word. So if there's a word that can be fought over, that's what happens. That's the Markman process. And that's the initial step. Once you know what the claims mean, then you look at it like a punch list. Does whatever you're accusing of infringement have all of the elements that are in the claim? And again, only the independent claim. So we're going to ignore the dependent claims for this. If you go back and you look at a claim, let's go back to the bread, and it has everything that's in claim, the independent claim. So here, claim one, then there's infringement. So if I make a sandwich with a first piece of bread and a source of protein on top of it, but I make it open face, I don't have a second portion of bread, then I'm missing that second portion of bread limitation, and I don't infringe. Okay, you've got to have every single thing that's in the claim. You can have more. So if I have at least one source of protein and I have lettuce and tomato and whatever else you want to add to it, then that's fine because I still have everything that's in the claim. But if something is missing, there's no infringement. So ideally, if you're obtaining a patent, you want this to be as broad as possible. So instead of jumping right in and claiming a sandwich with 2 pieces of bread, you might want to start with 1 piece of bread and a source of protein and see how prosecution goes. The examiner may force you to add things. That's very common, but you at least want to start out very big. If you start out too narrow, it may go through, but you're giving the scope away. Okay. Does it make sense how we look at infringement? I'm not hearing any no's. No no's means yes. Okay, I know we've added a few more people in the last few minutes. Any questions, comments, please jump in as we go. You do not have to be muted. You do not need to use the chat. It's a lot easier if you just speak up. The more interaction here, the better. So what we just looked at on using a punch list and looking at every word as they're written is called literal infringement. That's the most basic type. That's the easiest to prove. If you're the patent owner, you want to show literal infringement. It's got all the elements as written. If you don't have that, there's something else that's called the doctrine of equivalence. So that means that everything's not met as written, but the difference is insubstantial. And there's a test for this. It's called the function way result test. So if we have a claim that says claim 1, I claim 2 pieces of wood connected by a nail. Literal infringement is if you have 2 pieces of wood nailed together, they're connected by a nail. But if someone comes along and connects those 2 pieces of wood by a screw, that's not literal infringement because it's not exactly what it says. So then the question becomes, is that screw basically the same as a nail? And you look at what's the function of the screw, how does it do it, and what's the result? You know, the result being it holds them together. And typically a rivet or a screw oftentimes would be the same as a nail, right? So you might have infringement under the doctrine of equivalence. You have to keep this in mind because if your claim says screw or nail and you're looking at something else that says screw, it's real easy to say there's no infringement because it's different, but you have to keep this test in mind. Now, if an element is completely missing, then the doctrine of equivalence does not apply. So if we go back to the example I just gave, and instead of 2 pieces of wood nailed together, let's say that the claim says a first piece of wood, a second piece of wood, and a third piece of wood nailed together. And something only has 2 pieces of wood nailed together. We're missing the third piece of wood. We're missing something entirely. So it's not that it's being done differently, it's simply not there. And if something is simply not there, the doctrine of equivalence doesn't apply. Okay, are we making sense? All right. The next limitation on the doctrine of equivalence is if that limitation was added during prosecution, then you're stuck with it typically. So if we go back to the sandwich example above, and in the sandwich example above, we have a first portion of bread, a second portion of bread, and the protein, right? Let's say that our initial claim that we gave to the patent office said a first portion of bread and at least 1 source of protein adjacent the first portion of bread. Okay, that would have covered an open-faced sandwich. But the examiner said, no, I'm not going to give you that. So we came in and we added that second piece of bread. By adding that second piece of bread, we are now stuck with it. We can't come along and say that something is equivalent to it. We're stuck with what we added. So if it's a limitation that was added at the patent office or argued at the patent office to try to get your patent, doctrine of equivalence typically doesn't apply. So as we're reviewing claims for infringement, what we'll typically do is we'll look at the claim and we'll go through and we'll mark it up based on the prosecution history. So we'll pull the file of what happened at the patent office and mark everything that was added and or argued. And all of those things are not open for the doctrine of equivalence. We know that those have to be there as written. Okay, we still making sense? Okay. So far, based on what we've talked about, hopefully it makes sense on what is infringement, how do we look at claims, and which claims matter, right? That's the initial part of this, because we can't design around a patent until we know what does a patent cover and how do we determine infringement. Okay, next step. Now, at this point in time, you know what is infringement, how do you look at the claims, and how do we go about analyzing it. We'll put it into practice in a little bit. The next thing to know is the patents don't last forever. So utility patents generally, and there's two types of patents. Let's start with that. Utility patents, they protect how something functions, how it works, the components that make it up. So it's, what does this device do? What does this software accomplish? Design patents protect how something looks. So it's the aesthetic elements of a device or something, some product. It's how that product looks. It's not that it necessarily performs differently. It's not that it's necessarily made differently, but it looks different. So for utility patents, functional patents, typically patent term is 20 years from your earliest priority date. Provisional patent applications don't count. There's a way to file what's called a provisional patent application, get your information at the patent office, and then within a year, file your full-blown non-provisional application. And that's oftentimes done for speed purposes, for cost purposes, especially with startups. Startups oftentimes will file a provisional because it's cheaper. So it's cheaper initially, and then within that first year, you come back and you provide the full formal documents. That provisional filing doesn't count against your term. And there's some times that the 20 years doesn't exactly apply. Sometimes if you have multiple patents, you have to make sure that the later patents don't extend beyond the earlier patents, so you can cut some term off. And then also, if the patent office takes too long in reviewing an application and it's their fault, you can get some time added on. So 20 years is a good benchmark, but you've got to be careful on a per patent basis. On design patents, on the other hand, it's not based on when you filed, but it's based on when it grants. Older design patents used to be 14 years from date of issuance, and you can tell on the patent itself, because the patent itself will tell you if it's a 14-year patent or a 15-year patent for design patents. Newer patents, the last few years, the term changed, and newer patents are good for 15 years after issuance. Okay. Design patents, once you have it issued, you have your design patent until it expires. Utility patents, you have to keep up. 4 years, 8 years, and 12 years after issuance, you have to pay a maintenance fee. If you don't pay those fees, it goes away. So those are very important fees. If you're 8 years in and you've not commercialized it, you've got no thoughts of commercializing it, it's not been successful, you've determined it doesn't work, you're probably going to not pay the fee, it'll go into the public domain, and you no longer have protection. So these 4 years, 8 years, and 12 years are very important. The reason why I'm talking about term, I'm giving you guys things very specific today for infringement and for design around. If you spend a lot of time reviewing patents that are expired, you've wasted your time. So the idea is, let's go ahead and knock patents out first by saying they're no longer in play. If a patent's expired, you can't be held liable for infringing it. So that's why I want to make sure you understand the patent term situation, because that really cuts down on a lot of work and review. Okay. Next step. How do we identify things that are problems? So known assertions. Sometimes I have clients that are in an industry and they're looking to start commercializing a product, but someone else has already gotten sued by doing so. That's a known assertion, right? You know that somebody's got a patent, you know that they've already sued on it, you know that the chances of them litigating further might be very high. So that known assertion is something that you definitely want to watch out for. Second way is patent marking. If you see a product and you like the product and you want to market that same product, you need to look and see if that product says that it's patented. If it says that it's patented, then it's appropriately marked and you've got notice that there's a patent that you need to be aware of. So patent markings they can be very effective. The next way to identify potential problems is through searching. So this is through different patent searches, clearance searches. You'll hear it called different things. Clearance, freedom to operate, it all means the same thing. So the next step is to look at searches. Especially with startups, you guys typically have a lot of choices to make. Where do we spend our resources? Do we spend it on product development and manufacturing? Do we spend it on marketing? Do we spend it on legal? How do we best spend our money? And I can't tell you what's best. It's going to be company by company, and it's going to depend on your risk tolerance and other features. You know, if you start selling a product and someone sues you, are you willing to move away from that product? Do you have a lot of sunk cost into it? Is it very difficult or hard to move away? How much inventory do you have? How much time have you spent? All those things are factors that you need to consider. So on one end of the spectrum of searching, we could search for just known competitors. You can say, I'm looking to enter this space. And I know that company A and company B are the main players in this space. And I want to make sure that company A and company B don't have any patents that are going to cause me problems. With that, we can search just those companies, we can focus it, and it's going to be a lot cheaper than at the other end of the spectrum, we look at everybody, right? So known competitors is kind of searching light. Everybody is searching heavy. So, and you can go anywhere in between. You can say, these are my two main competitors, or these are the six people, the six companies that are in the market. There's two main ones and four others. Let's do all six. And there's no right or wrong answer here. So this is a company by company decision based on some of the factors we talked about before. The next step is to determine, what are we searching? If you have created a product and it has 8 different components, are we searching all components? That's going to be, again, on the heavy side of the search, the more complete, the full side. If your product has 8 components, but what you're really interested in is just one. There's one motion detector. You've got something and it has a motion detector. So you are interested in anything else in this space that includes motion detectors. Then we can focus on that element. So if you've got software that does 20 different things, and 18 of those are fairly standard, but you've got these 2 new steps or 2 new processes that are really what's important to you, then instead of searching all the different features, maybe we focus on those 2 features. Okay, that's going to narrow it down. It's going to make it faster. It's going to make it cheaper. And oftentimes that'll get you what you need. Okay, because if you're in industry and you know that these 18 features are very common, that they're not problematic, then by searching those 18 features, we may be wasting time and money. As we mentioned earlier, patents are country by country. So if you're going to sell in the United States and you're going to sell in Canada, we need to do a search in Canada also. If you're going to Australia, we need to go to Australia and do a search in Australia. Just because you can sell something here doesn't mean you can sell it there. And just because you can sell something there doesn't mean you can sell it here. It's important to know, even if you do the fullest search possible, you search all people, any inventor, any company, you do not limit it to any individuals or companies. And even if you search every feature of your product, there are limitations. Anything that's been filed in the last 18 months is not publicly available. So if someone filed something 17 months ago or 17 days ago, I can't find it in most cases. Okay, and you just have to accept that this is a known black hole. It doesn't make the search pointless. Now, if you're in an industry that's brand new, it's growing all the time, there's innovation happening fast, and most of the innovation is likely going to occur in the last 18 months, the search may not be as useful. The last 18 months is typically what we can't access. Okay, everyone's still clear? Okay, so now we've done our search. Let's review the search results. Step number one, based on the things we talked about earlier, has the patent expired? If the patent's expired, you don't need to look at it further. We don't need to go back to the claims. We don't need to say, what are the independent claims? We don't need to mark them up. We can say this patent is not a problem. So that's why it's important to understand patent term. Sometimes people will ask about repatenting something. Something was patented 30 years ago, the patent's expired, can I patent it again? No, the answer is no. Once a patent's expired, it's expired. People will ask about extending patent term. We talked about how you can get some extension on based on what happened at the patent office if it went too slow. But after your term expires, you can't renew. You have to pay those maintenance fees, but once your 20 years is up, your patent's expired with whatever term extension you got at the patent office. All right. If the patent has not expired, then we go look at the next steps. And what's the next step? We look at the independent claims. So that's why we talked about independent versus dependent claims. Ignore the dependent claims. A patent can have one independent claim. A patent can have 100 independent claims. You've got to go through and identify which of the claims of the patent are independent. For each of those claims, you then say, do we have every feature here as written? Use it like a punch list. If you've got everything as written, you've got a potential problem. If not, then we say, does it have the equivalent? Back to the example of the two pieces put together with a nail. We don't have the nail, we have a screw. Is the screw equivalent to a nail? If yes, we've got a problem. There's a little flow chart. So you start out, has a patent expired? Yes, you're good. Game over, you're done. If it's not, are all of the claim elements met literally? Do you have everything that it says? If not, we go and do the doctrine of equivalence analysis that we talked about. Okay, if it's not met under the doctrine of equivalence either, you're good. You can clear that patent, it's clear and over. If it is met under the doctrine of equivalence, then does the doctrine of equivalence apply? If not, back up to you win, pass go, collect $200. If not, then if a doctrine of equivalence does apply at that point, you've got a potential problem. We come back here. All right. This is a real easy flow chart, kind of lays out the process. This process makes sense. Again, no no's means yes. Okay, now we know how to do the analysis. And earlier we talked about there being multiple ways to address potential problems. If there is a patent that's a problem, one solution is to license that patent. So you go to the owner of the patent and you strike a licensing deal. Or if it's a component that you're going to be using, excuse me, you buy it from them. Because once you've bought that component from them, their rights are exhausted. So it works kind of like a licensing deal. So go through the appropriate patent owner. That's number one. Number two, challenge the patent. You can challenge the patent at the patent office or sometimes in court. That can be expensive. The government fee right now for challenging a patent through an inter-parties review at the patent office is just north of $40,000. And that's just for the government fee. So it's not a cheap endeavor. Other option, you can ignore it. If you know of a problem and you ignore it, that might be okay. You might get lucky. But if you get tagged, you can get tagged for 3 times the amount of damages. That very well could be willful infringement. And if you're a willful infringer, you knew of the infringement and you did it anyway, then that can triple your damages. It's not a good situation. Finally, design around. And that's what the rest of our conversation is. Although really everything we've talked about has led up to this, right? We've got to know what we're doing before we can design around it. So to design around, and this is a term of art. It's not something that has an exact definition, but basically what it means is that you've removed at least one element from your product from each independent claim. And if doctrine of equivalence applies, you also cannot include the equivalent. So if we're going back to our punch list, and we'll walk through some here in a minute, we want to take one of those punch list items and make sure that we do not have it either literally or through the equivalent. As you're doing this process, you want to document it. You want to document it very, very well. Because if you get sued later, you want to be able to show that you, in good faith, did address it and try to design around it, that you weren't a willful infringer. It can often help to have an opinion of competent counsel. So an attorney, you get a letter that says, I've looked at this, it doesn't infringe, and here's why. You put that in your back pocket. If you ever get sued, you really shouldn't be seen as a willful infringer because you took the steps, and that should keep you from triple damages. And then as you design around, you should also consider patenting it. So if you're doing something different, does it make the product better? Does it make it cheaper to manufacture? Is there an advantage in what you've done? And if so, you might want to protect that, because once you've gotten around someone else's patent, you might have a lot of people that are just copying you in the marketplace. So can you protect what you're going to be selling? Examples. I've got some somewhat silly examples, guys, because silly examples never hurt anybody. What we've got here in big picture terms, you've got someone with piercings on both eyebrows and glasses that attach to those piercings. So let's look at the claims themselves. So frameless glasses attaching to a body. And we know that claim 1 is it an independent claim or a dependent claim? Independent. Hopefully everybody answered that right. When we look at claim 2 depends back from claim 1. So if we look at claim 2, the improvement of claim 1 wherein, since it depends back to claim 1, claim 2 is a dependent claim. For our purposes here today, we are going to ignore claim 2 entirely. Also, let me make this clear. I believe I selected all patents that have expired. I'm not 100% sure on that, at least I believe I did, whether through term or non-payment of maintenance fees. So we're going to ignore looking that over. All right, these are just examples, but that would have been your first step. All right, claim 1, in combination with a body piercing eyebrow studs. So in combination with these eyebrow piercing studs, a left stud fastened outbound on a left eyebrow and a right stud fastened outbound on a right eyebrow. Okay, so that's where our studs come in. And then an improvement comprising. And this is where it tells you what they've patented. A left eyeglass member, so one of our eyeglass members, having a first stud attachment member fastened to a section of the eyeglass member. Okay, so they've claimed this and this. A right eyeglass member having a second stud attachment member fastened to an outbound section of the eyeglass member. Okay, we're good so far. We're in step C, or element C, a connecting bridge joining the left to the right eyeglass member, and where each stud attachment member may fasten onto a respective left or right stud. Okay, this is our punch list. When we go to say, do we infringe this? These things here are what we have to look at. If we create something that has all of these things, we've got infringement. Now, if we start taking these things away, so if instead of something that attaches to, this requires a left having a first and a right having a second. Let's say that we sell eyeglasses and we take this one off. Everything else is the same, but it only attaches to one side. It doesn't attach to both sides. Very straightforward, there's no infringement. And not only is there no infringement, literally, there can be no infringement through the doctrine of equivalence because something is completely missing. Remember, if you've taken something away, no infringement. Okay, what are some other ways we might go about changing this? Let's say instead of this setup, let's say that we have one piece of glass that goes all the way across. Kind of what I'm envisioning is like an Oakley's sunglasses type lens. And we still have two of the attachment members. Okay. But if we do that, we no longer have the connecting bridge. Okay, we've taken the connecting bridge away. So that's going to, again, take something out. So Jay and I were talking earlier, and I told Jay that this is fun. I don't know if you agree with me yet, but you've not gone through the process yet. And
Dustin, I'm having so much fun.
Well, I'm glad someone else is. I'm having a great time.
Okay.
It's fun because you get to design something. So you're coming in, and especially on the attorney level, it's fun for me when clients bring us in on this because we're giving options. And it's not, this is what you must do. It's, can you do this? Can you do this thing? If you change this so that it didn't have this feature, can you make that work? So it's a real creative process. So as you're looking at the claims, you say, how can I do this differently? And you can even come up with something that at the end of the day still attaches to the face without legs that go over your ears, but you've got to do it different. Okay, this is the design around process. Does that make sense so far? Okay, let's look at another example. A portable misting umbrella. And with this, let's go ahead and walk through it. A portable umbrella having a reciprocating canopy. So here's our canopy, and it must reciprocate with an inner and an outer surface, a shank attached to the canopy at a central location on the inner surface. So we're going to have a shank in here. The shank terminates in a handle, okay? And the canopy selectively reciprocating between a stored position adjacent to the shank and an unfurled position. Okay, so right now we know that this has to collapse, right? To infringe their claim, it has to be able to open and close. Without looking at the rest of the claim, if you are going to make an umbrella that does not open and close, do you have infringement? No. Hopefully everybody in that internal monologue is saying, no, we do not have infringement. We do not have what this claim requires. So we're already around this claim. And if you came in and your product is an umbrella that does mist, but it doesn't open and close, you can stop right there. You don't have to go through the rest of it because you already know that you don't infringe. If you do have that element, then let's look on. A distribution tubing network attached to the inner surface or canopy. So you know it has to have distribution tubing and you know where it has to attach. At least one spray nozzle attached to and in fluid communication with the distribution tubing network. So now we know that there has to be tubing and there has to be a spray nozzle. If you're going to have tubing to get to somewhere to have an output, but let's say that you're not going to have a spray nozzle. Maybe you could have a different type of applicator. Maybe it's simply a drip. Maybe it is something different. And this is where you would have to sit down and give it a little bit of thought. But if we're not going to use a spray nozzle, then also we're outside the scope of this claim, right? So that's something you could look at. How do I get water out without having a spray nozzle? A plurality of ribs pivotally attached to the shank. So here's our ribs. And extending therefrom, each of the ribs individually attached to the canopy. So here's where they're attached to the canopy. Here's where they're going to be attached to the shank. A ring slidably received by the shank. So here's our ring. And a plurality of spreaders. Each of the spreaders attached to a separate one of the plurality of ribs. And it has some additional limitations. So hopefully from what we've discussed so far, you've got in mind. What do we do here? We've already checked out the date. Again, this one has hopefully expired, but if it hasn't, that's when you would look through it. And then you start going element by element. Do we have all of these things? How do we remove one of these things? What do we get rid of? What do we do different? That's the design around process. Is it making sense? Alex, you've been with us through the beginning. Is this fairly clear on the process?
Yes, yes. It's really, I'm really enjoying it. The designs and the details and all of that.
Anything that's not clear, anyone, please speak up, because it's not useful if you walk away with more questions than answers, or if we could have answered things that you're thinking. Excuse me. All right, let's look at another example. Here's another fun example, and we've got a combined beverage container and shading apparatus comprising a beverage container for containing a beverage, means for removably attaching the apparatus to the beverage container, something for attaching this apparatus to the beverage container, a shaft coupled to the means for removably attaching. So here's going to be our shaft. And extending vertically with respect to the beverage container. So that shaft has to go vertically. An umbrella coupled to the shaft at a point above the means for removably attaching. So it has to couple up here and not down here, so as to shade the beverage container. Okay. Last element says, wherein the means for removably attaching comprises a clip provided to attach to the beverage container by means of a spring action and friction. All right. Let's talk about design around. Where would I start on designing around this? One thing I would look at, can we do something that's not a clip that attaches by means of spring action and friction? So instead of something with springing, is there something that attaches differently? Can it attach like a koozie, for example? You know, that's not a spring action. You just, it just houses it.
A magnet, for example.
Say again.
A magnet, a piece of magnet to
A
attach.
magnet. If you could connect by a magnet would be a great example because you're not using a spring action. You're accomplishing this some other way. So that's probably the place to start here is, can we couple it differently? If you really wanted this coupling, then what else can we look at? Something else that comes to mind while we sit here, instead of having the shaft and the umbrella, and we have specific attachment points, maybe we have a different type of umbrella. Maybe this umbrella extends all the way down to the clip in a great big curve, such that we never have this vertical shaft at all. All right, if that's our setup, then we can still have the spring clip because we're taking away something different. We're taking away the shaft. And we're just left with this umbrella that's a little larger that extends all the way down to the clip. Okay, either one of these is going to get you out of infringement. Excuse me. Practically speaking, the more things that you change, the more clear you are. Does it only take one to not infringe? Yes. But if we have 2 or 3 things we can argue, and it turns out that we're wrong on one of them, then something else still kept you from infringing. So if you're in court and you can say, I don't infringe for these 5 reasons, you're oftentimes better off than I don't infringe for this one reason, because you've got additional things that you can rely on. So it can be very helpful to change more than one thing. Also, practically speaking, if I'm in court on a product and I'm representing the defendant, the person that's accused of infringing, the more different it looks from the patented product, typically the better off you are. And that's not a legal rule, but it's a practical rule, because oftentimes judges and juries don't like copiers. So they like to see that you've got something different. And the more that difference stands out visually, the better off oftentimes you are. So that's not a legal tip, but is absolutely something to keep in mind, that you want to look like you've done something different. You don't want to just have done it differently. You want it to appear that you've done something differently as well. Okay, hopefully that makes sense. All right. At this point in time, we've talked about what patent infringement is, how you analyze it, how you go about designing around it. And let's tie back to what we started with, which is this is a useful process for not just you, but for the public at large. Because if this very valuable drink umbrella is being sold for $20 and you've come in and you can do it whether through magnets or a koozie or a larger umbrella, and you still get the same overall effect, but you can take it to market for the $18 price point, the public just won, right? So part of the idea here is bringing costs down by doing things differently. So this is not a bad process. It's not something that the patent owner is going to like, but it is just simply part of the patent system. All right, we've stepped through design around. Does anybody have any questions at all? And I'm serious, I really do prefer conversation. This has been more me droning on than any of us probably would have preferred.
Justin, I have a question. You were talking about domestic versus international, and then you mentioned just because you can sell something in the US doesn't mean you have permission to sell it in other places. Do you mean you don't have protections when you're selling it in other places, or do you mean like actual permission to sell it in other places?
It can be both. If you have patent protection in the United States and you want to go and sell it in Canada and you don't have a patent in Canada, then someone can come and compete with you fairly in Canada, even if they can't do that in the United States. But you might be locked out of a certain market, because even if you're okay to sell in the United States because someone else doesn't have a US patent that blocks you, they very well may have a patent in Australia. So when you go to enter the Australian market, you may have a problem there and you may be locked out, or you may have to go through this process in a different country. So it really is country by country, both for protection and for not being sued.
Thank you.
Hey, Justin, this is Matt. So, really this is for the benefit of Alex, but when you talk about, designing around, obviously, generally you're talking about a third party's patents, right? But, if Alex puts forth something with us, say today, right, and 5 years from now, he's confronting art, but it's his own art, right? And the thought process is in some cases very similar. What did you say, right, in the application? What did you say during prosecution? Where did the claims fall? But, how do you approach that, from kind of this early stage where you are confronting perhaps your own prior art, right? And whatever you landed as far as your background or IP, how do you approach it, given the standard is sometimes different when you are confronting your own art in terms of how you overcome it, right? You have a plan, but the sword that's used against you is often, well, you reasonably knew, or your prior filing or paper taught where you're ending up now. How do you confront that, or do you have any guidance as far as an inventor confronting their own art, and that's the art that is a primary concern?
And you're absolutely right, Matt. So the design around process that we've talked about today is really for third-party patents and infringement. But it happens very frequently, and especially for individuals, startups, small companies, where they create a product iteratively. So there's a version 1, there's a version 2, and by the time they're happy with it, it's a version 8, 10, 12, whatever down the road. If you have disclosed version 1 publicly, then that is going to be used against you as you try to obtain patent protection. So if you've not disclosed it publicly, if you've kept it inside your company, excuse me, you've not sold it, you've not printed any papers on it, you've not discussed it in classes, you've not talked to your neighbor about it, then that's not going to count because that's not a disclosure. But if you've disclosed version 1 and now you're at version 2, and let's say you're happy with version 2, you get ready to go do version 2. If that version 1 was publicly available, it's going to be used against you. So you have to do some of these same procedures and say, what do I have that's different? What makes me patentable over myself? Now, the way to avoid that is to patent as soon as possible, or at least file an application as soon as possible. So if you filed an application on version 1 as a provisional, for example, then that's going to give you a year to do whatever testing and changes and to come back and file your non-provisional application. After that, you can file what's called continuation in part applications. Excuse me. But those have their own pitfalls, especially if you're going to litigate. I've invalidated patents that are continuations in part based on the parents. So it can cause problems. The best advice I can give is to not disclose unnecessarily until you're ready to move forward with it, and then to do everything you can to get an early filing date, and then to get your changes done quickly and to get your non-provisional in.
And as far as kind of that, that decision when you're early, you could put in more or you can put in less for your first filing. Where do you come out given kind of current case law as far as, what do you put into that first filing? Do you try to plan out, a certain period of time, say 5 years, and here's our primary best mode and top embodiment, here's, how we would change it or potentially change it? Do you try to track a course for, up to a certain point and try to enable as best you can all of that? Or do you go, okay, this is our first filing, we're not going to disclose more than this, but this is what we're trying to get as far as the bite of the apple. We're not going to disclose the remainder. Our second filing is going to predate. How do you go about doing it? Is there a best practice in your mind?
Yeah. So and this is a full hour, if not a day, topic in and of itself, which is also a lot of fun. One of the first questions is, are you going to keep anything as a trade secret? If there's something that you're going to keep as a trade secret, then of course we don't put it into a patent application because that can come out to the public at some point. So if there's a secret sauce that you don't have to disclose and you're able to maintain it as a trade secret, let's take that off the table. All right, now once we've gotten rid of the trade secrets, I would include as much information as possible in your provisional. I would get a filing date for everything you can. And the more information, provisionals do not have to have a certain format. They don't have to have pretty drawings. They don't have to have a full claim set. I typically would include at least one claim, but provisionals can be bullet point lists. They can include pictures. They can include shop drawings. They can include whatever written way is best for you to get information to the patent office. Anything that's in that document is going to give you a filing date, and your filing date is important. I've got a litigation case right now where we're litigating a patent that first was filed as a provisional, and what we're fighting over is, did the provisional disclose everything that's claimed later? Do I get that provisional file date? The more stuff that's in there, the better off you are. If you include things that you're not going to do, okay, that's probably okay. That's probably okay. Could you be putting a roadmap for somebody else to take a different route? Potentially, but you could also potentially patent that route. So the more stuff you put in there, the more things you can ultimately stop people from doing. Keep in mind also, a patent is not the right to go do something. A patent is a negative right. It keeps other people from doing what we talked about earlier: make, use, sell, offer to sell, and import. So the broader protection that you have, the more you can keep people out of the market. So I would suggest filing as much as you can, as early as you can.
And then fight the enablement fight if it comes later, but have it in there, have some options versus hold back and hope for
Yes.
the best. Yeah.
Absolutely.
So I have one more question. Right now, like I'm working with Tulane, right? And my application that I'm creating is in partner with an innovation institution.
Yeah.
So when I try to patent some of the stuff I have in my application, how can I approach like that? And can I like you said, you just mentioned I can add the stuff that I'm going to do. Like, is that something in an institutional and academic level allowable? Like just adding the stuff I'll keep adding doing?
Matt is going to be the best guy to talk to about that, because that's really between you and Tulane and how you move forward with the patent process.
Yeah.
So there are a lot of issues there on inventorship, ownership, patent strategy, and that's probably a little bit more broad than this open forum today.
Mhm.
Yeah, Alex, we can get together on that, right? So there's an ownership piece to this, right? It's a charting a course as far as entitlement and for how long. But, the biggest kind of take home here related to this is, putting pen to paper. You could reduce it to practice by virtue of, putting a patent application together, as Justin's talking about. So you need not always to have done it research wise, right? But you do got to be able to teach it, right? With the requirement that, it doesn't require undue experimentation for someone skilled in the art in your space to do or reproduce what you have described in your application. So if you can meet that standard of teaching, right, and show that it's not just an idea, but, you practically laid out how to do it, or knowledge in the field would close those gaps, you can put it into the application having not experimentally done it in certain cases, right? It's easier in certain spaces than others to kind of lay it out that way, right? Mechanical being one of those, right, arts. But, you can put it together and reduce it to practice by virtue of the patent filing, not always dependent on the research lab. So you can kind of forecast where you're going, put in a prophetic example, describe and give description around the full metes and bounds of what you think your invention is and what it could be optionally now and into the future. So,
All right. Sounds good.
that
I think we'll have to get together.
yeah.
Okay. All right.
All right. That looks like my cue to jump in. Thank you all for staying a couple minutes over. Love the discussion that we had. Justin, thank you so much for a really accessible presentation. As myself, I come with very limited prior knowledge, and I was taking notes and I was with you every step of the way. So I think the way you presented it and that flow chart was really helpful. Also, I will be thinking about eyebrow piercing affixed glasses probably for the rest of my life. So coincidentally, Alex, you're the guy of the day because you're also on my slide. I wanted to let people know about some upcoming opportunities at the Innovation Institute. So first, if you like this webinar, we do have a couple more coming up on the 19th of February. We have a webinar about building a physical prototype. And then on March 12th, we have one on IP monetization strategies for startups and entrepreneurs. As with all of our webinars, if you're not able to join in real time, simply register and we will make sure you get a recording of it. Next, I wanted to highlight some opportunities for funding, which Alex is very well acquainted with because he's done both of these things. He's our star student, apparently. So first, applications for the Provost Proof of Concept close technically on Friday, but there is a little bit of a grace period until Sunday. So if you're working on something at Tulane University and you want some funding to bring it to the next level, conduct some customer discovery, Alex is giving many thumbs up because I think it's a really helpful grant for researchers at Tulane. So that application closes on Friday, March 24th. Applications for Open Mic Night close, which is our medical innovation challenge. Pitch competition. This is very early idea stage. So this is very much like you wrote down an idea on a napkin and you want to tease it out a little bit further. So if that is of interest, please look at our website for that application link. And then finally, I want to highlight some opportunities to see entrepreneurship in action. On February 24th, we are having our Young Entrepreneurs Academy Investor Panel. And then on March 26th, it is Tulane Innovation Day as a part of New Orleans Entrepreneur Week. This was a lot of information on this slide about what's upcoming because Innovation Institute, we like to keep things busy. So we do encourage you to go to our website for any additional details, or you can shoot me an email and I'm happy to guide you to the right resources. Again, Justin, thank you so much. I have a page and a half full of notes from today's talk. I feel like I really learned a lot and we're so appreciative of your time.
Thanks for having me.
Thank you so much.
Bye.
All
Thank
right,
you.
y'all, have a good Wednesday.